Hello dear students, today we will discuss insider trading. The main objectives of this lecture are to study the concept of insider trading, to trace the development of insider trading in India, to analyze and interpret the regulatory framework dealing with insider trading in India, to study the approach of judiciary towards insider trading, to examine different penalties in case of violations. First, let us look at introduction. Insider trading or insider dealing is the illegal practice of trading on the stock exchange to one's own advantage through having access to confidential information. Insider trading is the buying or selling of a security by someone who has access to material, non-public information about the security. Insider trading can be illegal or legal depending on when the insider makes the trade. It is illegal when the material information is still non-public. Illegal insider trading includes tipping others when you have any sort of non-public information. Legal insider trading happens when directors of the company purchase or sell shares, but they disclose their transactions legally. Insider trading is defined as a malpractice wherein trade of a company's securities is undertaken by people who, by virtue of their work, have access to the otherwise non-public information which can be crucial for making investment decisions. When insiders, for example, key employees or executives who have access to the strategic information about the company, use the same for trading in the company's stocks or securities, it is called insider trading and is highly discouraged by the Securities and Exchange Board of India to promote fair trading in the market for the benefit of the common investor. Insider trading is an unfair practice wherein the other stockholders are at a great disadvantage due to lack of important insider non-public information. However, in certain cases, if the information has been made public in a way that all concerned investors have access to it, that will not be a case of illegal insider trading. Since insider information gives an investor an advantage over others, it is illegal and punishable by law. Let us look at some illustrations to explain the point. The CEO of a company divulges important information about the acquisition of his company to a friend who owns a substantial shareholding in the company. The friend acts upon the information and sells all his shares before the information is made public. Similarly, a government employee acts upon his knowledge about a new regulation to be passed which will benefit a sugar exporting firm and buys its shares before the regulation becomes public knowledge. Another illustration, a high-level employee overhears some conversation about a merger and understands its market impact and consequently buys the shares of the company in his father's account. The effect of insider trading is borne by those who are not aware of the confidential information due to this. They do not deal in securities. Insider trading is unethical and amounts to a breach of fiduciary position as it involves a breach of trust and confidence. The misuse of insider information is discouraged for numerous reasons. Insider takes unfair advantage over the information deprived person. It results in a conflict of interest as it is beneficial for insiders' self-interest and not in the company's best interest. It lowers the market reputation and acts as a disincentive to investment. Now, we will discuss insider trading in India. In India, instances of insider trading have been and continue to be persistent form of market evil since many decades now. Such instances were first reported in 1940s when directors, promoter, agents and other officers of the companies were found to be using insider information for profitable speculating in the securities of their own companies. During the decade of 1940s, insider trading did not attract much public fury because of the lack of public alertness about the truth that the profits made by insiders were pulled out from the innocent public share. It was unchecked till late decade of 1970s when it was finally recognized as unfair as its instances came into the limelight in the Indian stock market. In 1977, the Sachar Committee opined that Section 307 and Section 308 of the Companies Act 1956 was insufficient to curb the malaise of insider dealing and recommended fuller disclosure of transactions by those who have price-sensitive information and prohibition of dealings by such persons during specific period. The Government of India constituted Patel Committee to make a comprehensive review of the functioning of stock exchange and to make recommendations to the government on this matter. It recommended that insider trading should be regulated and declared as an offence having statutory prohibition, and that to prevent such activities, stock exchange authorities should be empowered by law to take disciplinary action themselves and to file civil and criminal proceedings against offenders so that they do not go unpunished. Another recommendation made by it was that persons misusing insider information also be compelled by law to surrender to the stock exchange the profit that they may have made or the amount equivalent to the losses that they have averted. Abid Hussain Committee in year 1989 was considered as a gateway to the introduction of insider trading laws in India and recommended that it could be tackled to large extent by appropriate regulatory measures, and thus proposed that insider trading be made an offence with both civil and criminal penalties. It stated that Securities and Exchange Board of India should formulate necessary legislation wherein it is empowered with the authority to enforce the provision. Now, we will discuss regulation of insider trading in India. First, we have Securities and Exchange Board of India Act 1992. Based on the suggestions of various committees, the Government of India set up the Securities and Exchange Board of India (SEBI) as the first statutory regulatory body to regulate the securities markets post the reforms of 1991. Section 11 of the Securities and Exchange Board of India Act 1992 describes the power and functions of the board. Under Section 11, Clause 1 of the Act, it is the duty of SEBI to protect the interest of the investors in securities and to promote the development of and to regulate the securities market by such measures as it thinks fit. Under Section 11, Clause 2, Subclause G, prevention of insider trading has been specifically mentioned as one of its duties. After the amendment of 2002, Section 12A of the Securities and Exchange Board of India Act 1992 explicitly prohibits insider trading in securities of companies listed in stock exchange. Section 12A of the Act reads, and I quote, "No person shall directly or indirectly engage in insider trading, deal in securities while in possession of material or non-public information, or communicate such material or non-public information to any other person in a manner which is in contravention of the provisions of this Act or the rules or the regulations made thereunder," unquote. Violation of Section 12A attracts civil penalty under Section 15G of the Act up to 25 crore or 3 times the amount of profits made out of insider trading, whichever is higher. Insider trading is also a punishable criminal offence under Section 24 of the Act with imprisonment for a term which may extend to 10 years or with fine which may extend to 25 crore rupees or with both. Under Section 11C of the Act, SEBI is empowered to undertake an investigation where the board has reasonable ground to believe that the transactions in securities are being dealt with in a manner detrimental to the investors or the securities market or any intermediary or any person associated with the securities market has violated any of the provisions of this Act or the rules or the regulations made or the directions issued by the board under it. In respect of public companies about to be listed on stock exchanges, the board may, under Section 11, Clause 2A of the Act, undertake investigation of books and records, etc., if it believes that the company has been indulging in insider trading. Now, dear students, we will discuss the provisions of insider trading contained in Companies Act 2013. Section 195 of the Companies Act 2013, read with Section 12A and 15G of the SEBI Act, also governs insider trading in India. Section 195 of the Companies Act 2013 provides that no person, which includes any director or key managerial personnel of a company, shall enter into insider trading. Exploitation of unpublished and confidential information belonging to the company is a breach of duty, and the company can ask the director in question to make good its loss, if any. In Saltman Engineering Company Limited versus Campbell Engineering Company Limited, it was held that use of such information can be restrained by way of an injunction. Now, dear students, we will discuss SEBI Prohibition of Insider Trading Regulations 2015. So, the committee report formed the basis for introduction of the SEBI Prohibition of Insider Trading Regulations 2015. Exercising its power under the SEBI Act 1992, SEBI came up with the regulation of 2015 on 15th January 2015, which replaced the earlier regulations governing insider trading in India. The primary objective for the introduction of the regulation has been to strengthen the legal and enforcement framework, align Indian regime with international practices, provide clarity with respect to the definitions and concepts, and facilitate legitimate business transactions. It seeks to address the inadequacies of the regulation of 1992, establish a legal structure which conforms to global best practices, and consolidate the changes effected by circulars, notifications, amendments of enactments, and judicial precedents concerning security laws in India since 1992. The SEBI Prohibition of Insider Trading Regulations 2015 comprises of 5 chapters, 2 schedules, and 12 regulations. Chapter 1st deals with definitions. Chapter 2nd deals with the restriction on communications and trading by insiders. Chapter 3rd talks about the disclosures to be made by the companies while trading its securities by insiders. Chapter 4th prescribes a code of fair disclosure and conduct. Chapter 5th contains miscellaneous provisions. These regulations were further amended in 2018, 2020, and 2021. Dear students, now we will discuss applicability of SEBI insider regulations. The regulations only apply in listed entities. In case the company is unlisted, its listing is pending, including listing application is pending, then also this company will fall under these regulations. No applicability on private company or public unlisted company. Now, what are the key features under the regulations? First, insider means any person who is either a connected person or is in possession of or having access to unpublished price sensitive information, which is called as UPSI. Therefore, it includes persons connected on the basis of being in a contractual, fiduciary, or employment relationship that allows such person access to unpublished price sensitive information. UPSI has been defined as information not generally available and which may impact the price. This definition provides a test to identify price sensitive information, aligning it with the listing agreement and providing a platform for disclosure. Restrictions have been placed on communication, procurement, and trading in securities when in possession of UPSI. Insider cannot communicate to outsider. No person shall procure from or cause the communication by insider of any UPSI relating to a company or its securities listed or proposed to be listed to any other person, except via such communication is in furtherance to legitimate purpose or performance of duty or discharge of legal obligation. The regulations provide for certain exceptions which include in the conduct of due diligence, for off-market transactions, a trade executed in the absence of any leakage of information, and trades executed in the pursuance of trading plans. Qualification criteria have been set up for compliance officers who shall report to the board of directors of the company or the head of the organization, as the case may be. Now, dear students, we will discuss significant penalties. SEBI may impose a penalty of not more than rupees 25 crores or 3 times the amount of profit made out of insider trading, whichever is higher. SEBI may initiate criminal prosecution. SEBI may issue order declaring transactions in securities based on unpublished price sensitive information. SEBI may issue orders prohibiting an insider or refraining an insider from dealing in the securities of the company. Now, dear students, let us look to some case laws. First, we have DSQ Holdings Limited versus SEBI. A promoter group company was held to be an insider within the meaning of Regulation 2E. There was violation of Regulation 3 Clause 1 and therefore debarment from dealing in securities for 5 years. The information in his possession related to rights issue. Another case is Samir C. Arora versus SEBI. it was held in this case that the person in question must have access to price sensitive information, which means such unpublished information which when published would affect prices of the company's securities. Another case is Diamond versus Oriamuno, where the directors sold their shares before publishing half-yearly statements, and the market went down after the publication because the accounts were not according to expectations. They were held liable to hand over profits to company. Now, dear students, we will move to concluding this lecture. India has put her best foot forward in making a move towards the enactment of the regulation of 2015 with an aim to align its laws on insider trading with that of the developed countries. It is certainly a praiseworthy effort in course of renovating the legal regime to address challenges and deficiencies of regulation of 1992. It introduces stricter and more determined provisions along with plethora of new concepts for improving the level of protection granted to the investors with an aim to change the deteriorating scenario. The regulation seems to be headed towards making the stock market more business friendly, providing much needed flip to Indian capital market and facilitating further economic buoyancy. It appears to be hopeful, more realistic, and based on the global approach to insider trading, due to which it seems to be more equipped to ensure better compliance and enforcement. It seems to be effective on paper and seems that it shall achieve its intention of deteriorating the widespread insider trading activities. With this, we end today's lecture. Hope you enjoyed it. Thank you.